Good morning, and thank you for joining Thompson Hine's Weekly Coffee Chat Series. My name is Tasha Love, and I'm in the Investment Management Practice Group. Joining me today is Carrie Shufflebarger, partner in the firm's Intellectual Property Practice Group. In today's session, we will examine strategic approaches to seeking levels of protection for intellectual property. Maximizing IP protection typically requires registration with a federal government agency to safeguard those rights. We will discuss the benefits of registering and other considerations when building and maintaining brand equity. If you have any questions or comments during today's program, we encourage you to join the discussion by using the Q&A box on your control panel. We will address your comments as we move through our discussion, and we'll try to leave some time at the end to answer those as well. We promise to follow up with any questions we don't get to during our time together. So with that, let's get started. Carrie, just to get us started, would you mind providing us with a brief overview of various types of intellectual property and giving us some examples of IP within the fund industry?
Sure, Tasha. There's generally 4 different types of intellectual property, some of which are less likely to impact the client base in your practice group. For example, patent is the biggest one, and that's more of novel inventions. You can have patents in business methods and things of that nature, but I'm not going to talk much about that today. The second thing is trade secrets, which are information about your company that have inherent value by not being known to the public, and that you've taken reasonable measures to maintain that secrecy. Of course, the best example of that is something like the formula for Coke, but it also can impact clients in this sector as well, because, for example, you have customer lists and other business information that you wouldn't want your competitors to know. The big ones that I'm going to focus on today are first trademarks. What a trademark is your brand. It's a source identifier. It signals to your consumers that the goods and services come from you and that they're going to be the quality that customer expects. These trademarks have to be associated with a particular offering of goods or services. For example, Delta Airlines owns Delta for airline services, where Delta Faucet owns it for bathroom fixtures. The same applies here to your fund clients. Their trademark registrations will cover the services that they offer and not necessarily others. Trademark rights accrue from actual use of the mark in commerce. So to your point earlier about maximizing the IP protection, that is true to maximize the protection, but you have trademark rights if you are using a mark in commerce in connection with the offering of those services. And the fourth and final one I'd like to touch on today is copyright. And copyright is a very broad concept. It's any creative works that are fixed in a tangible medium. And those can be software, they can be works of art, they can be photographs, they can be text. For example, if you have documentation that describes your funds, your website, all of that stuff is protected by copyright as well. And again, copyright exists at the moment it is fixed in a tangible medium. I have copyright in the notes I'm using to talk to you today. Of course, they have no value to monetize through licensing or otherwise, but again, to maximize the protection, you should seek registration of those rights.
Thank you for that. And so in focusing on trademark rights and copyright marks, which are the most applicable to the fund industry, I know you mentioned that there are some rights that automatically attach to trademarks when you use the identifier in commerce. So what are some other ways that what are the benefits of registering for intellectual property, although it's not required?
Sure. Like I said, trademark rights develop when you're using the mark in commerce. And if you don't have a registration for it, I suggest that you use the little superscript, either TM for trademark or SM for service mark, to alert your customers and other people in the market that you claim you claim rights in that term that are yours. Now, what registration gives you is a presumptive nationwide priority. So, for example, if you're relying on your common law rights and you're only using that trademark within, say, the New York metropolitan area, you would have common law rights in that particular geographic area, but not necessarily in California or Seattle. What a trademark registration gives you is, it's like sticking your stake in the sand when you file that application. It's notice to the world that that's your trademark right and you claim it as presumptive priority anywhere in the United States. Trademark registration is also relatively inexpensive as compared to some types of intellectual property like patents that cost tens of thousands of dollars to secure. A trademark registration can be acquired with just a few $1,000s. The government filing fee is $350 per class, and then the attorney's fees to get it shepherded through the system, which usually takes 9 to 18 months. So it's relatively inexpensive and relatively timely to get that done. I've helped out several of our firm's fund clients in protecting either one, the name of their company and their brand, or the names of individual products within their portfolio. And we appreciate that this is a smaller investment for clients in this space. It's not like, say, a consumer product company that's going to have a large portfolio of different brands, such as a Procter & Gamble or companies that put out lots of different products. Your service offerings are narrow what you offer. So again, that makes it less expensive to move forward. And it's also relatively simple. There's only 5 pieces of information we need to get a trademark application on file for you: the name of the applicant, the identification of the mark, the identification of the services that are covered, and the filing fee, and then you need a specimen. Before you get to that, though, we always recommend that you do a trademark clearance search to make sure that no one else is already using that mark and that you may be stumbling into an infringement situation. And I can tell you, I cleared 2 marks just yesterday for some fund clients. So it's, again, a quick process. If you call us, we can do a quick search on the USPTO site. And if it looks like it's clear, we can also invest in a more detailed search for clients as well. Something else that's important for protecting your trademark rights is make sure you use them consistently, and use them as an adjective to describe your services. Trademarks are not nouns, and Google notwithstanding, usually trademark rights holders risk devaluing their brands if they don't use them consistently and correctly. And I mentioned Google just because they're the exception to the rule that people use Google as a verb, as a noun, as every part of speech that's known. As far as the benefits of copyright registration, like I said, copyright exists at the time you create the work, but if you want to enforce those rights, you have to have it registered before you can sue somebody for it. So that's more or less your ticket into court. Also, the Copyright Act is designed to encourage parties to register so that if it's registered before the infringement starts, you get more damages that you can get statutory damages, and also you're entitled to ask for your attorney's fees. So there's a lot of carrots built in there to encourage parties to register their copyright as well. As far as one thing I point out to watch out for with intellectual property is, in addition to protecting your own, make sure that you're not stepping on the rights of others. For example, be careful to avoid unauthorized use of third parties' marks who may not appreciate your use of their marks. And my favorite example of this comes up every February. Say you're having a contest and you're giving away Super Bowl tickets. The Super Bowl, the NFL very much frowns on the use of Super Bowl by sponsors who have not paid a lot of money to be officially sponsors. So that's why you see a lot of things like the big game around that time. Another big one that you have to watch out the use of is March Madness. Again, these rights holders they advertise and take a lot of money from people who want to be the official sponsors of these events. So always be careful when you're using those. Another thing to watch out for is unauthorized use of other people's copyrighted materials that you don't have a license for. And this comes up very often, for example, in your website design, or if you're running a blog or your social media feeds. It's so easy to right click on a picture and put it where you want it on your content. And unfortunately, that unless it's appropriately licensed, that's a risk that someone's going to come after you and they're going to object to your use of their intellectual property without appropriately licensing that intellectual property.
Thank you for that. And so I know you touched on this in part in your response, but what are some of the considerations or factors that our clients should be looking at when determining whether they should use trademark symbols or whether they should register, and then also the same in copyright as well?
Sure. If you have a brand, especially if it's a distinct brand and you have value in that brand, we do recommend that you seek registration for it. One, it maximizes the value of that asset to you. Second thing, it gives the world notice to kind of stay away from where you are. They don't want to get too close to you and infringe your mark. Also, to the extent you are engaged in any sort of acquisitions or transactions where intellectual property is an asset that the buyer may be interested in the value of, it serves two different purposes. First off, it's an asset that adds value to the portfolio of what they're purchasing from you. The second thing is if you've appropriately cleared and protected your marks, it minimizes the risk of third-party infringement claims and potential risks that you would have to disclose during the due diligence process.
Okay. And then we often hear this phrase in the industry about patent trolls or trademark trolls, and they're designed to kind of push people into relinquishing patent rights or trademark rights, or starting these patent litigation suits and things of that sort. Can you kind of touch on the aspects of trolls and the role they play within IP law, and then how companies can protect themselves from trolls?
Sure. The most common kind of troll is, of course, the patent troll. And I wouldn't be surprised if folks on this call have gotten letters, demands from patent trolls based on the technology you use or any certain things. They're just shaking you down for a license fee. They're not practicing entities, but they just want money for it from you. But I've also seen a rise in recent months and years in two other types of trolls that hit on clients such as yours that may not have a keen eye for fraudulent materials. The first one I want to talk about is the trademark renewal trolls. Say, for example, you rely on Thompson Hine. We register your trademark. You're cruising along. You've got a registered mark, and you get something that looks like this in the mail. It says pending trademark cancellation. It has all of your information on it, and it says your trademark is going to be canceled unless you pay them $970. This was actually a fun client that sent me this a couple weeks ago, panicking because she thought that her trademarks were going to be canceled, 3 of them, and she really didn't want to spend $970. It turns out this is a fraudulent company that puts a notice at the bottom that says Patent and Trademark Office, but has an address that's not the USPTO. And they send these directly to the client, not to the attorneys of record. And you would be surprised at how often clients who get these notices think they're real because they look very convincing, and then they pay the amount, and then the money's gone. The trademark registrations are not subject to cancellation. So I don't know who runs your mailroom, or these usually come in through accounts receivable, but be aware of these that come in, and make sure that if something looks fishy, call us, shoot it to us, and we can answer in 2 minutes and tell you that that's not real, and they won't be grifting money off of you. The second one relates to copyright and what I was talking about earlier, the use of third-party content on your website or in blogs. There are individuals and companies out there who own vast portfolios of copyrights in photographs, and they have technology that scours the web and finds where you've used a picture that wasn't appropriately licensed through Getty or through these companies that license such images. And then they'll send you a letter saying, you've used this illegally and you owe us $10,000. Now, usually the actual license fees, if you would have actually paid for the rights to use that on your blog or on your website, or even on your marketing materials that you send out in paper, would be $150, $400. So what these companies seek from you is an exponential amount higher than what it would have cost you if you would have just gotten the licenses. So the important thing, the key here is, one, if you get one of those letters, send it to us and we can usually negotiate it down to a lower rate. Two, see if you actually do have a license for that image through your service providers or otherwise, because a lot of times these companies and law firms, for that matter, send out these letters indiscriminately and then say, well, if you can prove you have a license, then you don't have to pay us, of course. But this is a huge revenue generator for these folks, and that they prey on clients who, again, don't have large intellectual property profiles, so they don't think they've done anything wrong, because that somebody in the chain right-clicked and saved it to their social media site. And so beware of that. It's always important to appropriately license content. And one other point I should have made earlier, as far as ownership of copyright, anything created by employees of your company is owned by you. If you use independent contractors to create content for you, it's a little more iffy, and you may need appropriate assignments to own the rights in that content. Now, I suspect that you have folks in your marketing department who are well versed on this, but again, these are easy questions that we can answer shortly. I see a question we have as far as negotiating the 10. Mary asks, when you say you can negotiate the 10,000 down, are you saying down to a usual 150, or are you saying more like 5,000? It depends on the situation. For one thing, it's usually not the 150, because they want and would get, if they went to court, a little bit more of a punishment, if you will. Courts generally will award damages that are around what the damage actually suffered was, but at that point, if they went to court, there would also be attorney's fees and things of that nature. So yes, we negotiate them down usually to like the $4,000 range, but something else to keep in mind, at some point, it doesn't make economic sense for these attorneys to bring these causes of action. For example, they would rather bring say you are I'm trying to think of a good example here. You're an influencer on YouTube, and you have all kinds of content that's infringing. They're going to get more bang for their buck going after 20 infringements on one site than they would your use of a stock photo of somebody at a signing, a transactional signing that you just use the stock photo for effect. But it really depends on the circumstances, and also it depends on how deep of a pocket the copyright owner feels like he has on the hook. And it's unfair, but you know, some people actually make a living off of the litigation. I'm currently dealing with this exact same situation for a large company, and they used a photo several years ago in a PowerPoint that was given at a university, so it was even academic. They've now been sued for them, and the photographer is seeking $80,000. So obviously, it's worth it to litigate them, because it's not this particular copyright owner is unreasonable, because I think our client would have easily paid him that $5,000.
Thank you. Sorry, I was checking the chat here. We had one other comment to you, Carrie, when you get a chance to review that.
Sure. Depends on how egregious the offense and how deep the pocket is. Mm-hmm. That's absolutely right. Mm-hmm. So one other thing, I touched on appropriately indicating trademarks, with the SM or the TM. I didn't hit on what all you could protect as trademarks, in addition to just your brand name. Also, if you have a design trademark, if you have invested the money to have something that's a little more distinctive, say the golden arches or the Nike swoosh, something like that, that is also protectable as a trademark. And also, if it is distinctive enough and it has original design elements, it can also be subject to copyright protection. So you can double dip on some of your intellectual property as well. It's not limited to just one kind. So it's always, if you have any questions, give us a ring. Joanne or Tasha or someone can hook us up, and we'd be happy to look at your website or your materials and sort of audit and make suggestions on maximizing the value of what intellectual property you have.
I think we lost that. Oh, there you are.
Oh, I apologize. One other thing that I do want to touch on as well. I don't know if clients in this space have the ability to let website users or customers or anything contribute content. Tasha, is that something that comes into play here at all?
We do. So under the advertising rule, third-party testimonials are now permitted with certain requirements that have been put in place by the SEC. So there is some social media advertising that is permissible now within the fund industry.
Perfect. That was before I went down that road, I just wanted to verify that it was relevant here. Be mindful of social media policies and compliance with those policies. Also be mindful of what your brand profile is on social media. I don't know if you invest in folks that monitor that, but it's a growing concern that you see in many different areas, because it's still sort of the wild west out there on social media. So it's a good idea to be well versed and protect your intellectual property through social media, both offensively and defensively there as well. Be careful, you guys have some extra regulatory authority there that's going to be careful on the advertising. And so I don't think I need to talk about the endorser and influencer pitfalls for you guys, because that would get in a lot more trouble than just the FTC on the trademark front.
Sure. So I did want to follow up on a point that you made earlier, and that not every company is of the size where they have the resources to devote to intellectual property and registering and making sure to secure those rights. So what are some of the things that you, aside from reaching out to us, of course, what are some of those things that those companies should be thinking about and considering in protecting their copyright and trademark and patents and things of that sort?
Sure. I can't help you with patents. That's a little bit out of my my price range. I have to be a patent lawyer, you have to have a technical degree, and I have a liberal arts degree, so I stay clear of the patent law. But as far as maximizing your protection, first off, appropriately use your intellectual property. Use the TM, the SM to mark what you claim as your rights. Always use the copyright symbol, the C in a circle, on websites or any content that you create or that you claim ownership of. It's a really easy way to put notice on the bottom of any documents. And also it signals that if somebody else wants to use it, they know who to contact to get permission. Also, be cognizant of how other people are using your brand or your mark. A tool I've used for decades, and it's really easy, is a Google News search. You can set reminders of if somebody's using your brand and it comes up on a Google news search. For example, I put my name in one, so I want to know if somebody out there is talking about me, and also for certain key clients. So if something comes up, I can be on top of it and notify them immediately that if somebody's saying something that's negative or there's easy ways you can do it on your own in-house without paying these brand companies that will do it for you for substantially more money. As far as the trade secrets, if you take value in something by keeping it secret, make sure that you are in fact taking steps to keep it in the hands of just those folks who need it. Oftentimes that protection comes into place through non-disclosure agreements and agreements of that sort that kind of gets more into the employment space and less into the intellectual property space. But the key there is making sure it keeps anything of value that you consider a trade secret is in fact kept secret. As far as patent, though, if you have any follow-ups on patent and you think you have an invention that may be worthy of protection, again, it's out of my pay grade, but we have fantastic folks here as well that can talk to you about that and let you know if you're infringing someone else, and two, if you have something novel that bears protecting as well.
Great. All great tips, Carrie. Thank you so much. The Google News is something new for me for sure, and it's something I definitely want to add to my repertoire, making sure that I'm keeping track of those things.
See, I'm letting you know. I'm telling you my trade secrets, Tasha. So.
Yeah. Well, that concludes today's chat. Next week, we are taking a Memorial Day break, so we'll return the following week on Wednesday, June 9th. My colleague, Mark Miner, will be joined by Hardin Compliance to discuss changes to New York's Blue Sky Law, which became effective last December. To register for this or future coffee chat discussions, visit the events page at Thompson Hine website, and we encourage you to view our library of past coffee chat recordings, which are available on Thompson Hine's YouTube channel. We want to thank you all for attending today's program and extend a special thank you to Carrie for sharing your insight into intellectual property law. When the webinar ends, you will be prompted to take a survey providing feedback. Thanks again, enjoy the rest of your day, and stay well.